Good afternoon, everybody. Welcome to the Samfiru Tumarkin Employment Law Show. We are live on Facebook, YouTube, I think Twitter or LinkedIn as well. My name is Chen. I'm an employment lawyer at our firm's Vancouver office. We have offices across Canada, but I work out of our downtown office in Vancouver. So I will be here live for the next half an hour until 1:30 or so. I'll be answering any and all questions to do with employment law, issues in the workplace. If you have issues with your severance, if you have issues with your boss, a colleague, bullying and harassment, discrimination, there's a whole variety of topics that come up in employment law. So anything and everything to do with your job, please feel free to type in your questions in the text box in front of you. And then for my regular viewers, I know that you know the drill, but for any new viewers, you type the question in. I'll be able to see it here. I'll read your question out, and I'll do my best to answer it. And everybody is welcome to follow up on their question, and I'll try to get through as many as I can. I can also, if anybody has any issues with disability coverage, long-term disability, short-term disability, critical illness, any insurance policies, I'm happy to answer questions on those topics as well. So yeah, please type in your questions. I have a few topics I wanted to talk about today, as I've been just issues that have come across my desk in the last month or so that I wanted to talk about, but I will put priority to the questions. So please feel free to cut me off if I'm talking about something else. But one of the main we got a first question here. So first question's here from Carson. Carson says, badly injured at work. You finally have clearance to return, but your boss says they cannot accommodate your restrictions and they're letting you go. Is this legal? So Carson, that's a really good question. It really depends on a lot of factors, right? And the main two factors are, what is your job and what is your restriction, right? So the legal term that this goes into is called the duty to accommodate. And every employer has a duty to accommodate in Canada under human rights legislation, right? Each province has different legislation for human rights, but they all have it. And so they have a duty to accommodate you to the point of undue hardship. Now, what does undue hardship mean? It's different in every situation. So if you're a firefighter and you're blind, right? If that's your restriction, no, the employer, the city doesn't have to accommodate you, right? That's an essential, requirement of your position. If you are an office worker, right, and you get, you have headaches or you have mental health issues, and you can only work a maximum of 4 hours per day or 5 hours per day. That's a lot easier to say that should be a reasonable accommodation than the previous example I gave, right? Where, firefighters, pilots, whatever, people who need their sight, if their restriction is they can't see, it's legal to say that they're not going to bring you back, right? So I guess the answer to your question, Carson, is it could be legal, it could be illegal. It really depends on what your restrictions are and what your job is. And sometimes, it depends on the size of the company as well. I've seen cases where the bigger the company is, actually, the higher the duty to accommodate is. So, and this goes into the ability of the company to accommodate. So a giant multinational corporation has to do more than the small mom and pop shop, right? Because they have more resources, more jobs, more money, probably. And so there's a lot of factors that go into that question. So hopefully that's a good general question for you. Okay, guys. So I think that's all I see for the questions. But for anybody that has any more questions, please feel free to type it in before I move on to my topic of the day. Okay, we got another question here. We've got a question here from Mariah. You were let go from your job without cause. You're on commission. You're on a commission pay plan. Do you have a right to your pre-sold deals and commissions associated with that? Uh, yeah, Mariah, that's a good question. So it's and I'm gonna give you, well, the answer is it depends, but let me give you some examples. So um, if you are let go without cause, right, which means you didn't do anything wrong, right? They just let you go, restructuring, eliminated your position, right? As in your situation. Generally, you have what's called a notice period, right? And that's what we call severance pay. So if you've been with the company like 50 years, you're 60 years old, you get 24 months, right? Or let's say you get a 24-month notice period. So the deals that would have closed during that 24-month notice period, you should be paid for. Okay. That's the general rule. So if you're with this job for, I don't know, 5 years and your notice period is 5 months, right? Deals that you would have been paid for in the next 5 months, that you would have been paid commissions on, assuming that deal closed and everything's all good, you should be getting that commission. That's the general rule. So, as with every general principle, there's exceptions, right? A few that I can think of, if you have a commission plan that um, says if we let, well, some I've seen some of them say if we let you go, if you're not actively employed, we don't have to pay you those commissions. Okay, I've seen plans like that. Whether those are enforceable or not is a different question, but that's one exception I can think of. Another one is if you have a contract, right? Some other contract that limits you to a notice period, right? That limits you to, let's say, 4 weeks notice, and your deals didn't close in those 4 weeks, right? Which means that you fall outside the period. Um, and so there are certain exceptions, and there's ways around those exceptions. If it's a substantial amount of money, right? If it's a few $1,000s or more, I would consider talking to a lawyer about it. If you're in BC, come talk to me. It's a question where it depends on a lot of factors, as you probably can tell from my answer. But I'd say the general rule is yes, you're entitled to those deals and the commissions as long as that deal closed, right? As long as the company, the employer, as long as they were actually paid for those deals. And obviously, it depends on the timing of when and what's considered a closed deal. But happy to chat with you more privately. So next question comes from Valencia. How do you deal with false accusations from a coworker? I feel like the manager is trying to force me out of my job, and I'm not sure what to do to protect myself. So, Valencia, this is kind of the one of the classic cases examples that I'd sometimes use for what constitutes a toxic workplace, right? And no employee in Canada has to deal with a work environment where they're being bullied and harassed, and false accusations, right? False accusations that the person making them knows is false. That's a form of bullying and harassment. Trying to force you out of your job by making these accusations is a form of bullying and harassment. So you don't necessarily have to deal with that, right? And so if the question is, well, there's a few ways to deal with it, right? And that's always the main question: is which way is best. You should definitely document, right, contemporaneous notes, every day that something happens, right? Today at 2:06 p.m., my manager said to me this, right? And just keep contemporaneous notes of what's happening at work, just so that it's some sort of proof. It's better than nothing, right? Um, you should also file, and this is always the hardest step to do, or one of the hardest steps, but filing a formal complaint with HR, or whoever at the company that deals with these bullying harassment complaints. There's usually by law there has to be someone that deals with these complaints at the company. Um, if it's sometimes the person that's harassing you though is the person that kind of owns the company. That's where the issues come in. But assuming that's not the case here, definitely consider filing an HR complaint and writing out exactly what the false accusations are and your response to them. Um, and depending on what the company does, that may resolve it. If it doesn't, then what you have to do is consider what's called a constructive dismissal. Okay. And a constructive dismissal is essentially something that the company does that shows that it's no longer bound by this employment relationship, that they don't want you anymore, right? If the company is trying to force you out without actually saying, you're fired, that's basically at law a termination, and no employee has to kind of stay in a workplace like that. If you're in a toxic work environment, if you're being constantly bullied and harassed, or if people are making false allegations against you every day and you feel like your manager is trying to push you out, you can claim a constructive dismissal, and claim for severance pay. And so before you do that, though, talk to a lawyer. And the main reason you want to talk to a lawyer is you want them to tell you if you have a case of constructive dismissal, right? Generally, a one-time comment, right, and one-time accusation that's false, it doesn't warrant that level of a constructive dismissal. And so talk to a lawyer before you do anything. But definitely in that situation, if you feel like the manager's just every day trying to force you out of your job, that sounds like a case, or a potential case to me at least. And so, document everything and file a complaint. And before you claim a constructive dismissal, talk to a lawyer. I think those are the three most important steps. So I think that's all the questions for now. If anybody has anything else to follow up on anything I said, please, like I said, I'm here till 1:30, answering your questions about labor and employment law. But the topic that I wanted to talk about today is changes to your employment relationship. And this is, well, the two main issues that have come across my desk are obviously, the economy's not, it's taken a turn. People are being let go. So I've had to deal with, severance issues a lot in the last few months. I've also had to deal with changes to someone's position, right? So an employee isn't being fired, right? They're not getting severance, but there's some sort of negative change to their job because of how the company's doing, right? The company's cutting back costs, or they're combining positions or restructuring. So what I've seen a lot in the last few months is employers unilaterally taking the action of changing someone's job. And that's not always a bad thing. Obviously, if you're getting more work, you're getting more money, and you're happy with that, that's a great thing, right? But the people that I usually talk to come to me with changes they don't like, obviously. And so I've had issues, the most common I would say is pay cuts, right? I've had a lot of people ask me about pay cuts. Generally, if the employer, I'll say this, so whether it's legal or not, if the company is doing it in good faith, right? If they're acting, because they have to cut costs or they're going to go bankrupt, they can cut your pay by a little bit to a certain extent, right? There's no magic number. When anything more than 10%, getting into 15% cut of your pay, that's where it becomes problematic. If they cut your pay, there's two things you can do, right? Number one, you have this action for breach of your contract, right? You have a contract that they're paying $20 an hour. They're only paying you $19.50 now. You could technically sue them for that difference, right? Because they're breaching the contract. The second thing you could do, it's a topic I mentioned earlier. It's called a constructive dismissal. If they cut your pay by 50%, right, you can actually just say, this is a fundamental breach of my contract. I'm going to claim constructive dismissal and claim for my severance pay, right? So you can do that if the pay cut is big enough. So keep that in mind. There's two options when you're faced with a pay cut. And it really it depends on depending on how big the pay cut is, there's different things you can do. The other things I've seen in the last few weeks, demotions is a huge topic. With restructuring, people are getting demoted. You don't have to accept demotions. Changes in hours is a tricky one. If you have a change in your hours of work, it could be something that entitles you to claim severance pay, but that's a trickier one. It depends on how big the change in the hours are, obviously, as well. Promotions. So believe it or not, but unwanted promotions could also be what's considered a constructive dismissal, right? If you don't want the promotion and they're promoting you anyways, that's not something you necessarily have to accept. But I guess that's a good problem to have. There's all these issues. So I think the bottom line for people to keep in mind, for employees, I should say, is if there's a change to your job, if it's affecting you significantly, if it's something you don't like, that you don't agree to, right? So it's a negative change. Don't think you have to accept it, right? You have options to say no, and one of them is just to get your severance pay and move on, right? And so it's something that you should seriously consider, because if you leave it for too long, right? If they cut your pay and you say nothing for 6 months, the law will most likely deem you to have accepted implicitly that change, right? So if you're dealing with some sort of negative change at work, you have to think about it right away and seriously consider what you want to do. And if the answer is this is something you can't live with, right? If it's just a change that you can't live with, and you don't want to do the job anymore, and you want to pursue some severance pay, that is an option. Like I said before, talk to a lawyer before you do anything, but just keep that in, I hope everybody keeps that in mind. So we've got another question here. Got one here from Steven. Steven's asking, can you be let go before the end of your contract date? And if you are, do you get severance? Yeah, Steven. So that's it's a good question. And sometimes you can, sometimes you cannot. Or actually, let me rephrase that. You can be let go before the end of your contract, but the key question is how much do they have to pay you out in severance, right? Most people I shouldn't say most, but in general, I see a lot of contracts that are for indefinite durations, right? There's no end date. Obviously, you have an end date in your contract. So if you had an end date in your contract, the next thing you have to look at is there a termination clause in that contract, right? Was there an agreement as to how much notice you would get if the company decided to terminate the contract? If there is a termination clause, and let's say it says 1 week's notice, right? The next question is that clause actually enforceable? So if your termination clause says 1 week's notice, that might not actually be enforceable. And so that delves into a separate area of law. If your contract is silent, which actually generally might be the best case scenario for employees, you could get paid out to the end of the contract, right? So you can imagine that if you have a 5-year contract and you're terminated 6 months in, right? Technically, you could claim for the 4.5 years left, and that would be your severance. So I think Steve, there's a lot of different, like all employment law questions, a lot of different things to consider. But I think that the general answer is you're definitely entitled to severance. The issue is how much, right? So hopefully that helped. So guys, I think that's please, for all the people, for all the viewers, please put in your questions in the text box. Anybody that's just joining us, you can put your questions in the text box, and I'll be able to see it in front of me here. Anything to do with employment law or human rights, discrimination, the Canada Labor Code, anything like that, please feel free to ask. So, I mean, the topic of changes to your job, I think I'll just, I think I've covered everything that I wanted to, but I think that the main takeaway that I hope people will have is, your job is kind of one of the most important things in your life. If there's changes to it, if there's negative changes to it, you have options, right? I've talked to one person recently where they said no to the change, okay, and the employer actually let them go because they said no. So there's nothing that prevents employers from letting you go, right? If you say no to the change, but because they let the person go, it was a very clear case for severance, right? And so that's a possibility that I think people should keep in mind. It's one of those issues where you have to, if someone's cutting your pay by 20%, people have a choice to you have to think about it, right? People have a choice if you want to stay for 80% of your pay, or if you want to claim severance and find a new job. And so I think it's important for people to know that they have options. They don't have to necessarily just quit and, get zero severance pay. If you've been with a company for, 30, 40 years, and all of a sudden the company cuts your pay by 20%, or they decide to demote you, they should be paying you out severance, right? Because even though they're not saying that they're firing you, through their conduct, the law is treating the employer's conduct or views the conduct as a termination of your employment. And so, yeah. See, so got another question here from Aaliyah. Aaliyah's asking, you started this job 8 months ago. They're mentioning that new hires will be classified as contractors, as this is better for us. This doesn't seem right. Okay, so that's one of the main issues of our time is contractors versus employees, right? There was the case of the Uber drivers, right, that went to the Supreme Court of Canada. Are they contractors or are they employees? The difference is, obviously, contractors, they get to write off deductions. There's no payroll taxes. They usually don't get benefits. They're supposed to have more freedom with their time, right? They can take multiple contracts with multiple companies. Whether it's better for an employee, I mean, it really depends on the circumstances, but a lot of people are contractors because there's more money in their pocket, right? The other side of that is they lose all the benefits of being employees. So, protection under the Employment Standards Act. Like I said, if you're in obviously contractors are in unions, and it's one of those things where even if you call yourself a contractor, a lot of cases have gone to trial and a judge will find that contractor to be an employee, right? So I've seen quite a few cases where the contract says, Mr. Smith is a contractor for the company, and we agree this is an independent contractor relationship. But Mr. Smith gets let go, and the company says, because you're a contractor, you're not entitled to any severance pay, right? Mr. Smith takes the case to trial, and a judge says, well, this is really an employment relationship, right? Just this looks like, well, just because the contract between the parties say he's an independent contractor, that doesn't mean much, right? You have to look at the total relationship and whether someone's actually an employee. And so in your job, Aaliyah, they've got these new hires who you're saying they're classifying them as contractors. Um, you don't necessarily, well, first of all, you don't necessarily have to accept that, right? You can say, no, I'm an employee. And second of all, at the end of the day, if you decide to do nothing about it, and let them classify you as contractors, a court may find you to be an employee anyways. Okay. But I think you should if an employee is something that that you want to be, right, because you have benefits, employment, you're protected by the Employment Standards Act. You should tell them that that's a requirement for you, right? But if you don't want to kind of cause a fuss or ruffle any feathers, a court may find you to be an employee anyways, despite the fact that your contract might say you're an independent contractor. Because and the main factors in that analysis are typically, how much control does the company have over you? Do they set your hours of work? Does all your income come from this one company? Do you work consistent hours? Do you get a regular paycheck, right? Because that's the real test. If anybody can just make up a contract that says that this person's a contractor, not an employee, everybody in Canada might be, the employers would make all their employees contractors, right? And so the law kind of puts that aside and takes a look at the total relationship. The Canada Revenue Agency, the CRA, does this as well, right? When people file their taxes as a contractor, they'll look at the relationship. It's a similar analysis, but not completely the same. Similar analysis, and they'll decide if you're a contractor or employee. So just because they call you a contractor doesn't mean you'll be found as a contractor, Aaliyah. So unless there's any more questions for today, I think that's it. Let me just double. Yeah, so I think that's it for the questions today. Guys, I'll be back in 3 weeks. I'll be back on March 30th. So if I missed anything today, I apologize, but I don't believe I have. But I hope everybody has a great weekend, and I will see everybody in 3 weeks.